My name is Brian Leiter. I'm the Karl N. Llewellyn Professor of Jurisprudence at the University of Chicago Law School in the United States. I'm here at NUS to give a public lecture on the law and philosophy of academic freedom, but I will also be giving seminars for colleagues in the philosophy department and the law school during my week at NUS. Academic freedom refers to the freedom of faculty in their teaching and research, their freedom to design their teaching and research in accordance with the standards of the academic discipline in which they work and without interference from external economic or political forces. Academic freedom is a more limited right than the right of free expression because the limits are set by the discipline in which the faculty member works. Someone who is teaching astrophysics does not have academic freedom to teach their students that the sun revolves around the earth. That is academic malpractice. Whereas someone might have a free expression right to say that as much as they want. So it's a more limited right, but it's a very important one for the success of scholarly research. So in the West, and of course I'm generalizing here, the main legal protections for academic freedom come from a mix of either constitutional provisions, statutes that protect academic freedom. That's the case, for example, in Britain. When Margaret Thatcher was Prime Minister, she ended tenure in the universities, and they passed a statute that protected, nonetheless, the academic freedom of faculty in the sense that I just discussed. In the United States, the protection is partly constitutional. That is, the federal courts in the United States have recognized that the First Amendment of the US Constitution, which is most famous for its protections for free speech, also includes a special concern for academic freedom. But interestingly, the main protection for academic freedom in the United States, and this is unusual compared to other countries, say in Europe, comes through contract law. Every professor has a contract with their university that includes the university's commitment to protect the academic freedom of the faculty member. This is not true of all universities, but the vast, vast majority in the United States. Constitutional protections in the United States only apply to professors at public universities. My university, University of Chicago, is private, so my protection for academic freedom comes from my employment contract with the university. But the US is a little unusual in that regard. In most countries, it's statute or constitutional. Germany is the most famous example of constitutional protection for academic freedom. So, of course, Asia is a rather large region of the country, and there are many different approaches that are taken. Some countries do not have academic freedom. China does not have academic freedom. Bangladesh does not have academic freedom. In some countries, like Japan and Taiwan, academic freedom is protected by the Constitution, and the courts have offered interpretations of this protection that are very extensive and go into great detail about its nature. Singapore is an interesting case because there is neither a statutory nor constitutional protection, but university leadership and government ministers acknowledge the importance of academic freedom. And that's very different from countries like Bangladesh, where government ministers and the universities do not acknowledge the importance of academic freedom. So the status of academic freedom in Asia varies quite a bit country to country, with very strong constitutional protections in some countries and no protection at all for academic freedom in other important countries in this region.